What's up, everybody? It's Supreme Decisions, and we're ready for another episode of the Legal Minute Podcast. Well, last podcast, I told you guys I was getting into something that was kind of taking away from the purpose of the podcast itself, and I'm going to get back to that today. But what I'm going to do is I'm going to add in something that's kind of the salt and pepper of this thing. Because we know no matter what you're cooking, you need proper ingredients to get this thing going. And a lot of times I hear people having a conversation or just flat out asking, do I still have a case if the prosecutor decides to drop the lawsuit or drop the complaint against me? And that answer is yes, because you've heard me I actually did a show in which I said a illegal act cannot precede a legal act. Well, in the most profound portions of this case, or in this matter, we get a chance to look at something, and it's either done through what is called a FOIA request or a Freedom of Information Act request, or it's done through discovery. Now, many of us have very little to no clue of what is supposed to be asked for during discovery, and apparently I did not cut my phone off. Well, in this episode, what I'm going to do is I'm going to go a little bit more in depth into a couple of the options that you guys have, or even I have, as far as if there is an opportunity for a case to be pursued further because of wrongful police misconduct. Well, one of the examples I'm going to use is one of my favorite targets, and it's the Phoenix Police Department. You guys can actually, I think 2 years ago, I started kind of picking on them because I went through Phoenix. And at the time, Phoenix was leading the nation in citizen, pretty much murders. You know, for lack of literally a better term. And the police chief at the time stated it was the citizens' fault that the police were shooting and killing at least one person every 5 days. Now, I also got into it with the police commissioner out in Phoenix in regards to the 4th of July in 2019, where there was an incident at Starbucks where there was a young lady, or actually a few young people, that asked the manager of Starbucks to either, hey, can we pay for those police officers' drinks? And they go sit somewhere else, or go sit outside, or take their coffee to go. And when they were asked, the 5 officers actually just agreed to leave, got their coffee and left. But the police commissioner stated that it was wrong for a citizen to not be comfortable around the police officers when, in fact, again, Phoenix was still leading the nation in citizen murders by police. And the conversation actually took place on Twitter, which later I guess you would call it, banned for like 2 weeks for bullying. For me actually pointing out and putting up a post, because while in Phoenix, I actually had got a newspaper. So if you want to go and check that out, it's either July 2nd or July 3rd, in which 2019, in which the cover of the Phoenix newspaper stated that 1 out of every 5 days, on average, a police officer was killing one of their citizens. And I stated, if I wanted people to be more comfortable around me, maybe I wouldn't murder them. And then there was a lot of people that actually kind of spoke up to it. But in this incident, there's a young man, Michael McGillis. He's Officer Michael McGillis Officer Michael McGillis had been involved in literally hundreds of DUI stops. And in the midst of doing DUI stops, Officer McGillis, Michael McGillis, had not necessarily lied, but he stretched the truth and violated department policy. Part of that violation was he was adding people as witnesses when in fact they were not even involved in the incident other than being there, which were passengers in a car. And procedures are kind of clear that they are not victims, as McGillis did, because what he stated to his sergeant why he was doing this, and he had done this more than 100 times. He stated he did this so the prosecution can have an advantage. Not that he was telling the truth, not that he was being an honest person, not even that he was trained that way, because he actually had to inform his superior officer of why he was doing it. He continued doing it. And it wasn't until a news story broke, which they started examining Officer McGillis' arrest and stops. Because you remember I did a podcast probably about a month ago now, in which I spoke about police officers using stock language. Even in this, if you're using stock language, and I tell you law is subjective, so not every situation is going to fit into the same box. But if I'm using stock language, that does kind of imply that every situation is pretty much identical, when in fact it's not. So what happened was this officer was looking around and adding this pretty much lie to offer an advantage to the prosecution, while in effect creating a means of the people that are in a car cannot be questioned by the defense because they are victims, because they're protected by the victim shield. And it becomes, if the defense goes to speak with them prior to cross-examining them, it becomes witness tampering. So using that shield, Officer McGillis allowed for a lot of innocent people who were not even drunk to actually go to jail, pay fines. And the crazier part was there was an unnamed officer in several of his stops that went along with his foolishness, even when noting that the person was either not involved in the situation that was being brought up, or proof that the person was not drunk or inebriated in any means. Now, why did I go through this elongated story? Well, this comes into the point of where I constantly talk about challenge every aspect of the stop. One means of doing that is getting a copy of the police report. Now, knowing is half the battle, so you know that it's going to be stock language placed into this pretty much report. So you know there's going to be a lack of actual truth and evidence. Now, what are some of the things that you can do as far as discovery and even on FOIA request? Well, here's what I did. I actually took it a step further because I wanted to look at something. And I've gone over, I haven't even given the cases on this, but I've gone over several means of the Freedom of Information Act when doing that request. I've even kind of given you something called the Open Government Act of 2007. And I told you every state must abide by federal law or have some kind of mixture of it that actually allows them to kind of free flow within it. And it's generally done through the organic code of each state, to say the least. So I want everybody to do this. You know, I'm doing a lot of rambling at this moment, but here's what I want you to do. The purpose of today is to get your pen and paper ready. I want you to actually sit down at some point. Go through your state's organic code. The organic criminal code of Georgia. The organic criminal code of BFE. It doesn't matter where you're at. Go through it, because you'll start to understand the different aspects of how your government actually is supposed to work. Because remember, I tell you, the reason why we're getting the police report is because he can't kind of say one thing on a report and then say something later, because that also has an effect, because it's called a lie. And once a police officer is caught lying, he is no longer viable for court. So anything that police officer has becomes fruit of the poisonous tree. I'll get into that, because even the prosecutor has to disclose that this person has lied, quote unquote, using stock language. Because even in this case, one person has prevailed in proving that this young man has lied. So the hundreds of other people that he has stopped now can appeal their cases. Now you see why whenever they're going through, and you're getting the fact that I tell you to go through each and every aspect of a stop, this is the one thing that you need to have that's very clear, without question. Now, I'm going to give you something, but this one comes from Texas. And there are several people that I'm having conversations with right now that are dealing with Texas. And even your, what do you call that? Your First Amendment auditors. This is something you guys can actually use. And it's one of the things that I actually kind of like. And I'm going to slip something in, right? Because I thought it was interesting, and it was something that was slipped in, and it came from Georgia. And it came from 11 Alive News. What they did, and I've actually done this as well, they requested the GPS location of an officer at a specific time on a specific date. Because what happens when you're giving specificity, you don't allow wiggle room. You don't allow a possibility for the lie to actually grow. You're giving something concise, and I use the ideas of sniper vision. Because there's a lot that goes around, but whenever you look at, or you're looking through that scope, the one thing you want to do, you want to look small so you miss small. If you're aiming for the heart, you shoot at a button. You stay focused on what it is that's in front of you. Now, the reason they asked for the GPS location was because there was a statement prior in his police report which stated he was somewhere else, when in fact, because he stated that, he can't argue against himself. So now he has to verify it. Why? Because anything else becomes hearsay. During the hearsay of this moment, you now have an opportunity to actually go after and examine what it is that's being brought for you. Now, I'm going to go through the Texas Government Code, Chapter 552. Well, if you understand the Freedom of Information Act, it's, I believe, Section 5, USC. Now, what happens is you have the rights as a requester. Now, keep in mind, you have basic things that you can ask for. You can access the information that is not confidential or otherwise protected. Now, why is that important? Because in the Open Government Act, there are 6 reasons for denial. Now, when we get into those denials, I'll give you the great thing, because I'm actually dealing with one of these in Virginia. And the funniest thing is a lot of times you'll hear them say, oh, well, we're not violating procedure, or it's not a Brady violation. The problem is they can't make a determination. It's not for them to make that decision. Because of Vaughn v. Rosen, Vaughn v. Rosen, 415 U.S. 977. It's a 1974 case. So the case itself is 57 years old. And also, when you're looking at the original 1976 Government in the Sunshine Act, there were certain things that were given. One is no record shall be requested if it is relating to national defense. Now, if you're talking about a traffic stop, there's a good chance that it's not relating to national defense. Now, no record is solely related to internal personnel records and rules. Now, here's the tricky part of that. You can ask for an internal personnel record and practices. Why? Because you can ask for a copy of a police department's policies when it comes to arrest. A lot of them have actually placed these policies, for the most part, in an online, I guess, forum, for the most part, or some sort of website where it can be easily accessed, not very easily understood, but it can also be certain personnel records. You cannot access one's actual home address. You can't get their social security numbers. You cannot get their phone numbers. You can't get their home addresses. You can't get like the actual protected stuff for the most part. But you can ask for badge numbers. You can ask for oaths of office. You can ask for records that actually have a means of, you know what? The judge said this. Well, great. Where's the policy that is written that that judge said this? You can ask for those things. You can ask for a record that is not directly accusing someone of a crime. Because again, that's why you have the opportunity to go after or even check someone's character. That's one of the things that's allowed. No record or information is disclosed which would breach the privacy because the records themselves are of public. Now, if you also go through, you'll understand that police officers often tell you, well, every time we make contact, we have to make a report. Guess what? It then becomes a public record. That report itself is something that you must be able to examine. No record will harm or delay the proceedings, and generally, if you're requesting certain records, especially for discovery, it would prove to speed the matter along to a conclusion where the absence would require a continuance. Generally, we have the instance of the defense or the prosecution not turning over discovery in a timely manner, because sometimes they actually want to give themselves 45 days, when in fact, if you file a motion for speedy trial, they only have a maximum of 90 days because it has to be done within that quarter. But this is part of the weaponizing, because here are the things that most of us don't know. Because a lot of us, I knew that, but yet we're not exercising that. We're not writing that down. We're not moving forward, and we're not pressing this. Why? Because we're still believing the fact that the police have the upper hand on everything. They control everything, when in fact they are the servants of you. Because you are the public. They took an oath to serve the public. The police is for the public. It is chosen by the public. The prosecutor or the DA is elected by the public. Because whatever they say, I'm speaking on behalf of the state. Guess who the state is? You are. When the judge is elected, he is elected by the people to act for the people. He is not above the people, or she. And in this matter, no record will lead to financial speculation or the endanger the stability of any lawful financial institution. Now, why would that actually be in there, especially when we're talking about records from police? Well, I often tell you guys about the fact that the policing system is actually set up for revenue generation, because we all know generally they're not going on or acting on lawfulness. They're acting on statutes, codes, and ordinances. Most of them are done where there is no, or as they call them, victimless crimes, which is an oxymoron because a crime requires a victim. Standing requires a victim with an injury that is fairly addressed to the actions of the defendant or the one accused. Now, if there is no victim, what actions can be fairly traced to the actions of the one accused? Who is making the accusation? Because even when I talked about the police report itself, it's showing the willfulness or the ignorance that they're practicing policy and not law. Because if there is a lack of victim, there is a lack of standing. So, as we go forward, I want you to keep those things in mind because not only have I given you those cases, I've also shown you how that works. But now, second part is you ought to receive equal treatment to all other requesters, including accommodations in accordance with Americans with Disability Acts and their requirements. Now, what happens is a lot of times we have those individuals, and yes, I got to get my sip on. You know, I've been trying to get this stuff together, so I want to do something a little different. So you got to excuse me. I'm going to take a sip. Now, you have those that don't have access or limited in their access simply because of their physical abilities, even in some cases their mental abilities. That's why they are still allowed to request things because, in essence, you're requesting your records, or you are requesting records that are available to the public or supposed to be available to the public. Now, when receiving certain kinds of information without exceptions, like voting records of public officials and other information, the reason why you're allowed to receive certain information about public officials, because a lot of times we have those things where there are obvious conflicts of interest, where you have a prosecutor or DA that's being paid from the exact same pool that a judge is being paid for. That is a conflict of interest. They are no longer a neutral magistrate when they have a vested interest in the outcome of any case. When you are looking at a written statement of estimated charges, especially when those charges exceed $40, in advance of work being started and an opportunity to modify the request in response to the itemized statement. Now, what happens is a lot of times we're not given an itemized statement of how much this cost is or why this cost is. Because whenever I'm giving you these things and I'm telling you to ask for these things, if you're doing a general Freedom of Information Act request, they're using the cost as a deterrent. Now, when you're going through the actual public record and you see it exceeds a certain amount of money, you now use that as a means of actually weaponizing against them, because now it's in writing. I'm going to then tell you who the action goes through. Because you get to choose whether to inspect the requested information, which is often done at no charge, or receive copies of information, or both. Because a lot of people don't understand the action of the inspection. You're able to go and inspect and take pictures. Most of that is not a problem. But it's the picking up when you're making the copies. Because again, there's got to be work done when you're making copies. But when you're going in and you're photographing just certain things, you're able to do that in the same construct. A waiver or reduction of charges if the governmental body determines that access to the information primarily benefits the general public. Now again, that goes back to cost. More often than not, they're not going to state that, yeah, you can go ahead and get this information, because it's not their job to give you something that can potentially harm them or cost them money. Because again, they're in the business of creating revenue. You can receive a copy of the communications from the governing body asking the Office of the Attorney General for a ruling on whether the information can be withheld under one of the accepted exceptions, or if the communication discloses the requested information and a redacted copy. I'm going to repeat that one because, one, I stumbled through it a little bit, but I want you to also pay attention to what's being said. You can receive a copy of the communications from the governmental body asking the Office of Attorney General of the state for a ruling on whether the information can be withheld under one of the accepted exceptions. I gave you 6 exceptions: national defense, internal personnel records and practices, accusing someone of a crime, disclosing privacy, harming or delaying a procedure, or going after a particular financial institution that is lawfully constructed. If you have that option, the Attorney General is the only one that can make that determination, not a staff clerk, not a judge. The Attorney General of the state makes that ruling, and it has to be done in writing. And there's a certain amount of time that has to be done in. You can then lodge a written complaint about the overcharge for public complaints of other possible violations may be filed with the county or district attorney of the county where the governmental body, other than the state agency, is located. Now, here's the great part about that. Even when you're doing the Freedom of Information Act request, there's a time limit on it. There's also an ask for an extension, which has to be done in writing. That same Attorney General has to make the determination of what cannot be turned over, not a district attorney. Why? Because here's the great part about it. The highest legal body in a state is the Attorney General. So what the Freedom of Information Act allows then is for you to actually sue those that you are requesting the information from in their individual capacity and their lack of response. These are the things that allow you to start getting people's attention. Now, the responsibility of the governmental bodies. All governmental bodies responding to information requests have the responsibility to establish reasonable procedures for inspection or copying public information and inform requesters of these procedures. Very few actually follow through with that last part. They're responsible for establishing these procedures. Many of them have actual public information offices or officers. Generally, they still do not handle these requests properly. 2020, where everybody was pretty much shut in, there was more than 200 Freedom of Information Act request lawsuits filed in 2020. This year, 2021, thus far, there has been over 150 Freedom of Information Act request lawsuits filed because the governing bodies are not setting up reasonable procedures for inspecting or copying or even answering the requesters. The governmental body also has to treat all requesters uniformly and shall give the requester all reasonable comfort and facility, including accommodation in accordance to the ADA requirements. Now, keep in mind, this portion is the guidelines for the state of Texas. Now, the reason why they're using this because the ADA is an actual federal guideline. This is the thing that you need to take note of because they're still following federal guidelines in the fact that they're doing this in any pretty much form. To be informed about open records laws and educate employees of the requirement of these laws. Many of us often know that none of them are very informed about what they are able to turn over and what they aren't, and many of them are not very educated on the requirements or law. Inform requesters of the estimated charges if greater than $40 and estimates, and to confirm the requester accepts the charges. They are to provide promptly and set a date and time to provide it within a reasonable time limit. Now, what happens is a lot of times they'll make a determination either off a past ruling or something that they believe is okay. What they're supposed to do is request a ruling from the Office of Attorney General regarding the information the governmental body wishes to withhold, and send a copy of these requests for ruling or a redacted copy to the requester. What many of them do is don't even respond, because the follow-up is where most people fall down at. Because just because there's been 150 Freedom of Information Act requests, that does not negate the fact that there were literally over 2,000 requests. Because you have to remember, less than 5% of all people actually fight back. Less than 5% of all people actually exercise their rights. And in essence, if you're not exercising your rights, you're giving your rights up. Now, the governmental body is also responsible to segregate public information from information that may be withheld and provide the public information promptly. Note that I'm going through this, and this is generally not being followed. They are to make a good faith attempt to inform third parties when their proprietary information is being requested from the governmental body. They're supposed to respond in writing to all written communications from the Office of Attorney General regarding charges of that information. Respond to the Attorney General Office regarding complaints about violations of this act. Now, the funny part is, most of them don't know, don't show, or don't care that they're violating one's rights. But in the same token, you have a young man in Virginia that planted evidence on literally 400 plus people. And very few of those actually fought back and requested the information that I'm telling you. They didn't have a proper discovery request. Now, I'm not saying they didn't have defense attorneys. I'm saying piranha don't eat piranha, and the option of going after what was done and said. Because keep in mind, I believe his name is Freitig. Freitig wasn't caught by police. He wasn't caught by a district attorney. He was caught from a third party that wasn't even going through anything at the time. That's what prompted the investigation, not someone fighting back. It was somebody being nosy. And Freitig happened to be in the way, and he ended up having body cam footage that got him caught. Now, there are ways of getting this information. You can request information by mail, fax, email, or in person according to the governmental body's reasonable procedures. Now, my thing is, whatever you do, if you do it by mail, you make sure you have a record of said mail out. If you do it by email, make sure you have a record, because again, it's not what you know, it's what you can prove. And if you can prove that you sent something out and received it, or it was received on such day, you now can enact the second part of this, which is the follow-up. Now, including enough description and detail, because when you're doing that, remember, I'm telling you to ask for specific things from specific people for a specific action. Now, what happens is a lot of us aren't doing that. Now, cooperate with the governmental body's reasonable efforts to clarify the type or amount of information requested. That is going to be done with the simple fact of being specific. So specificity, one, is their requirement, which is not done, but you now have specificity, which does not allow them to interject lies and deceit which allows you to be stronger when you move to the next portion of what your fight is. Now, information to be released. You may review it promptly, and if it cannot be produced within 10 working days, the public information officer will notify you in writing of the reasonable date and time when it will be available. I'm going to read that one more time because, again, this is even Texas. Why? Because even the Freedom of Information Act requires 10 days. The Freedom of Information Act requires 10 days, or they have to file for an extension with who? The state's attorney general. Now, I'm going to give you a couple of those things because I want you to understand what is being done. Keep all appointments to inspect records and to pick up copies. Now, going into the second part of this. By the 10th business day after a governmental body receives your written request, a governmental body must request an attorney general, a state attorney general's proceeding or exceptions. Notify the requester of the notify the requester of the information from the attorney general. Notify all third parties if the requester involves their proprietary information. Now, here's the great part about it. Not only is it giving you procedures of what you're supposed to do, but now we have the fallback. Because the failure to request an attorney general opinion and notify the requester within 10 business days will result in a presumption that the information is open unless there is a compelling reason to withhold it. And who has to make that determination? The state's attorney general, not the person you're requesting it from. The requesters may send a letter to the attorney generals arguing for release and may review arguments made by the governmental body. If the arguments disclose the requested information, the requester may obtain a redacted copy. Now, the redactation has to include one of these 6 from the Open Government Act of 2007, which is also involvement in the 1976 Government and the Sunshine Act, which set up those restrictions. If your request does not involve any of those, there is no reason for a redactation, or there is no reason that it will not be turned over. But note how many times I've spoken about the state's attorney general when you're doing a Freedom of Information Act request. Because the attorney general must issue a decision no later than the 45th working day from the date after the attorney general received the request for a decision. The attorney general may request an additional 10 working day extension. Whoops. Not the person you're requesting it from. So a lot of times whenever we're doing this, the requester doesn't do it and they don't notify the attorney general. So who has the responsibility of going through and notifying the attorney general? A lot of times what you want to do is you want to take that action on and let them know, hey, I've already sent this up to these people. This is what I'm looking for. Because the state's attorney general is the one that makes that determination. So now when you have officers like Michael McGillen that's planting evidence, that's using stock language, that's creating or making up things that go into a report and just playing who's the victim and creating something that's not there, you now have a source of support knowing not only who to contact, but where to contact them and how to contact them. Because you are the one that have the power. You are the one that has the force. You are the one that makes that determination. You are the one that do the exercise. You are the one that show them how great you are. And if you are truly tired of these horrible acts or acts of laziness, these are the things that you go after and that you change. This is the podcast for today. I hope you guys enjoyed it. I'm going to be back on probably on tomorrow. But until then, I love you guys, and good night.